And we're back after a brief break. You're watching South Texas Crossfire with attorney Joe Flores, reminding you to join us each and every week right here on KTMB and KVTV Laredo, and also on Facebook, YouTube, and Twitter. And you can also visit us at www.floreslawfirm.com. We'd also like to thank our sponsors, River City Hospice, 882-5900. Call today for your loved one, hope, dignity, and love. It's got to be River City Hospice. And Vasquez Flores Home Health, 361-881-9922, backed by over 20 years of experience. Priscilla Vasquez can help evaluate whether you can have a provider in your home. Stay home away from long-term care. Not that there's anything wrong with it if you need it, but again, providers to come into your home to help you with your activities of daily living. So we thank our sponsors. With me again, we have Robert O'Connor, federal judge back in the day and also still practicing law here. It's an honor to have you. How are you?
Oh, fine.
Well, I promised you and I promised our audience, I told them grab your popcorn and sodas because we're going to be talking about the federal system right from the horse's mouth, so to speak, as far as a sitting federal judge at the time for many years. And you were talking about the sentencing guidelines and things like that. A lot of people out there don't understand how the federal system works. And you were talking about the sentencing, that how hard even criminal federal sentencing can be. Tell us a little bit about that in our audience.
Well, the thing is that in state court, the defendant has a choice whether the jury sentences or the court sentences. In federal court, only the judge does the sentencing, and he generally orders a pre-sentence investigation, and the probation office then meets out the probation report, and you look at the report and then have but nowadays they have these guidelines so that you don't have any discretion as to the sentence if it falls within certain guidelines. And unfortunately, you might have a case which an exception to the rule might be applied because a first-time offender, the circumstances, so forth, but you can't take that into account if he falls within these guidelines. So they've robbed the district judge of the unfortunate responsibility of having to make a decision on their own. And I would think that you appoint good people will make the right decisions. Other than that, the sentencing is difficult, as I said before, because of the fact that your sentence affects so many people. I used to do my sentencing on a Friday afternoon, so I would schedule all the sentencing that I would be doing each week on a Friday afternoon, and then I'd go home and have a scotch and soda to try to get rid of the feeling. And so it's a difficult burden. Other than that, the trial of civil cases, a lot of cases that are federal laws do not have a jury. And I would say that the best way to handle those cases is to rule from the bench right after the end of the evidence. What I would do, say in a patent case, would be to get findings of facts, conclusions of law, not scratch on them as we went along, and then I'd dictate my findings to the court reporter at the end of the case, and that would be my findings of facts, conclusions of law, and judgment, and that way I'd be rid of the case.
Yeah, because a lot of the time they'll come back and appeal, and a lot of the laymen out there that aren't lawyers are saying, well, what the heck is that? Well, the lawyer's going to act, why did you rule against me?
Well,
right,
not only that, but the time sequence, because if you have a complicated case and you take it under advisement.
Oh boy, here we go.
I had a colleague on the bench that I went to see one afternoon, and he had all these exhibits out, and he had very expensive exhibits, and I said, what kind of case was this? And I said, it was a patent case, he told me. And I said, well, you just tried it? No, I tried it 2 years ago. And he had the court reporter there reading him the record and so forth. He'd put off ruling on the thing, and he'd forgotten about the case, and then he had to have the court reporter read her notes and decide the case at that time when it wasn't fresh on his mind. The best thing when you're trying a case is be like the jury. You ask a jury to decide a case right away, and they don't have any discretion to say, well, I'll come back next week, I'll try it, I'll decide
Sure.
it a month from now or whatever. They have to do it right away. So you put this pressure on those jurors to do it, and the judge should do the same thing. Just go ahead and rule from the bench, let everybody know where they are. If they don't like it, they can appeal. That's one thing, you don't have to be as careful as a district judge as you are an appellate judge, because as a district judge, you have somebody upstairs grading your papers, and they will say, well, no, you were wrong, Judge. So, well, I was wrong. But if I got reversed, I wouldn't try it again. I would recuse myself, say I gave it my best shot, let somebody else try it.
Well, and I mean, every judge has their own style.
Right.
Okay? And we got into some details there and some legalese and things. But the bottom line, end of the day, is that as far as, let's go back to the criminal, as far as the sentencing, so many factors, and you've practiced on both sides as a lawyer and as a federal judge, that when you go in there, a lot of attorneys don't practice in federal court as I do or as you have, because they're used to playing a little fast and loose, continuances, this and that in state court, kind of, and it's a lot more strict in federal.
Well, the judge has a lot of discretion in federal. He can comment on the weight of the evidence, which you can't do in state court. He can tell them, jurors, in his charge to the jury, he can tell them, I believe the man is guilty. He can tell them what he thinks.
And he picks the jury. He or she picks the
Well,
jury.
yeah, you have, of course, limited voir dire. In other words, the questioning of the jurors is limited in federal court.
Yes, and they primarily ask all the questions, the judge in federal court.
So you submit the questions to the judge, and he
Exactly.
decides whether he will ask them or not ask them.
That's
But
right.
at any rate, you go along lickety-split in that manner.
Right, yeah.
But at the same time, the judge has a lot of, he can inject himself into the case. I remember one of the first cases that I had was, I was court appointed by Judge Allred, and the DEA agent was on the stand giving his testimony, and the judge interrupted him. He says, wait a minute, aren't you going to object, counsel? What he's saying is inadmissible.
Yeah.
And I said, yes, Your Honor, I object.
Exactly, and
So-
that's real life. That's
Yeah.
that's not like Law and Order. The federal judge will comment and can do that. That's
Yeah.
within their broad discretion.
And at any rate, he was such a fair man that he didn't want to give anybody an unfair advantage. So he was, and he pointed out to me that I should have objected. So I did object, and the evidence didn't come in. So at any rate, he knew that I was a baby lawyer, and he was watching out for me and watching out for the client also.
Well, let me ask you this, and earlier you had talked about you knew the senator on a first name basis.
Yes.
You're very candid about all this because, people think a federal judge is just nominated on their ability. How many Harvard or Yale or UT trained lawyers out there that'd like to be a federal judge?
Well, the
Let me
thing is
ask
that
you,
I was,
how do you get chosen? It's also politics, isn't it?
in my case, it certainly was, because I wasn't a college professor. And they looked to those folks for appellate judges. And I was one of the few, I think, that were actually political appointees in a way, because I can't say that I was the best qualified for the job. I don't want to say that. I'm sure there are other guys that would have made better judges. But I was a practical fellow, and I knew I had a keen sense of justice since law school, because I didn't study that hard. I felt that my keen sense of justice would get me over the exams, But at any rate, I felt that I did a credible job, and I was called upon by judges here, for example, Judge Owen Cox called on me to come help him with his criminal docket
Right.
because he had held in abeyance all of these cases where they were trying to figure out whether Sarita was a functional equivalent of the border. And the Supreme Court had this case that was coming up, but it took about 4 years for the case to come up there, so he had this backlog of cases from Sarita, and so he called me up and said, I need some help. And I said, well, Judge, the only way I could help you is I plea bargain, and you don't believe in that. He says, oh, I don't care if you plea bargain. I won't plea bargain. In other words, I would take the recommendation of the U.S. Attorney because I felt if the government's satisfied, I'm satisfied. And so we did. I sent up Raul Gonzalez's brother, I forget what his first name is, and John Patrick Smith. I borrowed those two guys from the U.S. Attorney's Office. I sent them about 2 weeks ahead, and they plea bargained out 400 defendants.
Yes.
I had even one defendant that escaped from jail to come be sentenced in this group of people that are being sentenced. So, and also, but they left out a couple of guys. They left out a mafia guy that was, they said, we can't plea bargain him. And so I sentenced him in Houston, gave him a stiff sentence, and then got a death threat out of it. But at any rate, I got rid of his backlog, Judge Cox's backlog there, and he wouldn't have done it that way, but he didn't mind if I did it. So that's nowadays I don't think there's any plea bargain because you have the sentencing guidelines to interfere with that.
Well, we've got about a minute left, but you know, one of these things I wanted to thank you for coming on as a former federal judge and a practitioner, and now with our, we really congratulate Nelva Gonzalez Ramos for her role that she's going to play in the judicial system. What would you like to tell her, especially?
I would tell her what Judge Haney told me, just take it slow and easy. And, you know, it's a difference. She was on the appellate bench, I understand it. It's different in the trial bench because you have to decide things right then and there. You can't go back into chambers and brief it or have your law clerks brief it for you.
Right.
You have to decide right then and there. And I would tell her, just take it slow and easy and don't worry about making mistakes, that you have the appellate court to grade your papers. So that's what I would say, is just go ahead and relax and enjoy your stay as a U.S. District Judge.
Well, our half hour has flown by. I hope you come down and visit me again and become a permanent fixture here at South Texas Crossfire. We'd like to have you on again. And I just want to thank you for your time. And it's always an honor to have a federal judge and a practitioner on. If anybody wants to contact you or have any questions, what do they call?
Well, they'd call me.
And what's your number?
Oh, it's 713-227-7777. And I'm not looking to solicit any cases. I'm here enjoying a conversation with you.
Absolutely. And I always put that on there. This show never constitutes legal advice, nor trying to establish anything like that. Contact the attorney of your choice is what we always tell people. But really, I think you're an interesting guy, and I think that I'd like to have you on a little historical legal perspective on again here very quickly.
Thank you. I enjoyed being here.
And this is Joe Flores signing off for South Texas Crossfire. Please remember our sponsors appearing in front of your screen and on our commercials. And thank you, and God bless.